Good evening, class. My name is Teresia Gitau, and I will be taking you through company law. So welcome to today's class. We'll continue where we left off. So far, we have covered the nature and classification of companies, and we are currently in the formation of companies. In last week's class, we covered who promoters are, their remuneration, their duties, and the remedies against them when they go against those obligations that are required of them. From the date of incorporation mentioned in the certificate, the company becomes a body corporate by the name contained in the memorandum, capable of exercising all the functions of an incorporated company, with the power to hold land and having perpetual succession and a common seal, but with such liability on the part of the members to contribute to the assets of the company in the event of its being wound up as is mentioned in this act. You realize that the company mentions from the date of incorporation. What we are discussing today are the pre-incorporation contracts. Purport to act for something that is not in existence. So which are these pre-incorporation contracts that we speak of? And what effect do they have on a company that does not come into existence until, one, it has a name, and two, the memorandum and the articles are published, and a certificate of incorporation is issued. And as we have mentioned, under section 16.2, the company cannot be bound to the contract because it did not exist. Therefore, it had no contractual capacity. You realize it is not the company that entered into that contract, but the promoter on behalf of the company. So what happens to these contracts? And what is the effect? So at common law, as we have said, if a third party knew that the company was not in existence, he could make the purported agent liable on the contract. So in the case of Kellner versus Baxter and two others agreed on behalf of a company yet to be formed to purchase trade stock for its business. Later, the company was formed and accepted and used the stock trade, but it failed to pay for the stock. The court held that the company was not liable as it could not ratify a pre-incorporation contract with retrospective effect to a date before the company existed. You realize, as we were looking at who a promoter is, we said he cannot purport to be an agent of a company. The reason being, the company does not exist. So in this case, Baxter was unable to recover the money. But if it appeared that the contract was with a company already in existence, in the Newborn versus Sensolid case, a company purported to sell goods at a time when it had not been incorporated. The company's name was appended to the contract as Leopold Newborn, Land Unlimited, and underneath was the name of Leopold Newborn. When it was discovered that the company had not been formed, Leopold Newborn commenced proceedings for damages for breach of contract against the buyers in his own name. The Court of Appeal held that the plaintiff had never purported to contract or sell to contract to sell nor sold the goods either as a principal or agent. The contract purported to be made by the company, and Leopold Newborn had merely added his name to verify that the company was a party. In the circumstances, the contract was a nullity. Again, we reiterate the fact that you cannot be an agent for a company that does not exist. Therefore, the contracts that are entered into must be made clear. And whether the company once formed agrees to ratify these contracts will be based on the nature of the duty that the promoter applied. If he acted in a way that put the company at risk, the company has every right to refuse to ratify. And you that entered into a contract with them, probably for the supply of goods or services, you have no remedy in common law because you entered into a contract with something that does not exist. So in Schmaltz versus Avery, where a person purports to contract an agent, the only person in that case, the only person who had any contract with the defendants was the company, and Mr. Newborn's signature merely confirmed that of the company. At first instance, Parker J. expressed the view that if the principal had applied, the defendants could have escaped liability if they could have shown that they would not have contracted with the agent, meaning if they knew that the promoter was purporting to act and had no powers, if they can prove that at any given time they knew, then they would not have entered into a contract. What do we mean? If, for instance, right now, you are aware that an individual is purporting to be an agent of a company that does not exist, yet you go ahead and enter into that contract. You cannot, once the company is formed and the shareholders and the directors agree that the contract you entered into does not benefit the company and it is not ratified, it is nullified, you cannot go ahead and claim and sue for damages or restitution. But if you are genuinely not aware that this promoter was not acting in his fiduciary duties, and if you genuinely can prove that you are misled into believing that the company existed, then you can be restituted. The contract would be voidable and the defendants would have claimed rescission. But in that case, it was not necessary for the Court of Appeal to determine the circumstances in which an agent could claim to be the principal and thus enforce the contract. We have said that your state of mind when entering into these contracts matters a lot. You cannot, if you are well aware that this agent, quote unquote, because you cannot, a promoter is not an agent under law. If any contract you enter into and it fails, you have no restitution. But where you can prove that you did not know, then you have a chance to recover whatever you had invested in. Section 17, as we go to the registration of a company, we rely on Section 17, which says that a certificate of incorporation given by the registrar in respect of any association shall be conclusive evidence that all the requirements of this Act in respect of registration and of matters precedent and incidental thereto have been complied with, and the association, and that the association is a company authorized to be registered and therefore duly registered under this Act.